hearing regarding the text amendment. What's our case number?
ZT3-17.
Okay. We're going to begin our hearing again on the continuation of case number ZT3-17. Chuck, could you take roll call for this portion?
Mike Cornell.
Here.
James Blacker.
Here.
Richard Kiefer.
Here.
Richard Runyon.
Here.
William Flott.
Yes.
Joe Leering.
Here.
Joe Eastman.
Here. Okay. Tom told me that we've got 3 people here to testify tonight. I was only aware that Will was coming. We can start off with you, Will. I don't know if you had intended to stay for the whole hearing or not.
However you guys want to do it.
Okay.
Before we do that, can we find out from our legal counsel about what's admissible and what isn't?
Well, it's hard to address that question without knowing exactly what's supposed to be submitted, but I understand that considerations be given where the board can take judicial, or not judicial, but some kind of notice of certain facts. And the answer to that question is yes and no. Some facts are admissible, some are not. I could give you a detailed, the term judicial notice is well defined. But bottom line is and I don't know where this is going then. Okay, we might as well get into it. Is my opinion that you can take judicial notice, or take notice rather, official notice, of the ordinance that was passed in 2017 from the last text amendment, which was ordinance number 201704-14. And if you wish to take notice of the recommendation in ZT-3-16, but that's appropriate. But if you want to take notice of the opinions or the evidence submitted at the hearing, that is inappropriate. It's not appropriate to take notice of evidence from a prior contested hearing presented by witnesses subject to cross-examination. It deprives the applicant in this particular hearing of the right to confront adverse witnesses. So that is my opinion, and I don't know, Will, I don't know how that stands with what you have, or...
The report and recommendation that ultimately was adopted by the ZBA and then ultimately adopted by the county board can be taken judicial notice of. The facts and recommendations that are set forth, the witnesses were cross-examined by this board in very great detail. The exhibits that were admitted into evidence in that court file, or my reference court file, in that zoning file relative to that hearing, were also subject to cross-examination. You're dealing with the exact same ordinance pursuant to the judicial notice statute. It's the exact same. You're using the rules of evidence as set forth in the Illinois rules of evidence. There's a discretionary standard associated with this too, but due to the fact that I've already been subject to cross-examination dealing with the same evidence, I believe anything that was offered associated with that hearing can be admitted associated with this ordinance as well.
Okay, and the distinction that I'm making is that this is a different hearing than the applicant in this hearing. I realize it's the county board. Different text amendment does not have an opportunity to cross-examine those witnesses or to present evidence in rebuttal to those witnesses. So they are being deprived of their right to confront those witnesses.
You think the county is?
Yes. I did some research and I did find a case, and I guess, do you have a case that supports what you just said?
Yeah, I mean, are you wanting to talk to Will, attorney to attorney here?
No, I'm just asking. He asked a question. I knew it was coming. He knew it was coming.
Okay. Why don't we go ahead and have Will introduce himself and be sworn in, and then we'll proceed with where we're at.
Could he just tell us yes and no as we go along, so that we don't kill any time with it? He says that this is...
Do the strict rules of evidence apply to any zoning hearing?
There's flexibility.
Do they apply to any zoning hearing?
Strict rules of evidence,
Yeah.
no.
Okay, so that leaves Joan with the ultimate weight of
But I
the
was gonna say
decision.
that she is the chairman, and
That's
by her
correct.
own rules, she has a right to make the call.
Yeah, okay.
So, okay,
Mr.
well, go
Redmond
ahead and.
should probably think.
Would it just make sense to the chair if I just objected to the relevance of that prior testimony for the sake of time, for the sake of everybody here tonight? I would take dispute with the idea of Rule 201 of the Illinois Rules of Evidence. Yes, there is some language about it, but we're talking judicial notice from our legislative body, first of all, and second of all, certain things of public record, yes, but I will say I certainly would dispute the complete similarities of the past application and this application. We are asking for new text amendments and therefore just simply stating for the record that our objection be noted. Thank you.
Please introduce yourself, sworn in, and then we can,
I'm Will Gerber,
address, please.
21203 East 650 North Road in Fairbury, Illinois.
Okay, if you prefer to be sworn or affirmed.
Sworn fine.
Okay, please raise your right hand. Do you solemnly swear that the testimony you shall give in this case now and hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead and tell us what you're bringing in.
I've got marked what's, I'm assuming you just mark it by last name, Gerber Exhibit 1. This is the past text amendment findings of fact that were addressed at the previous hearing, adopted by the county board after the ZBA adopted the findings of fact. It was brought to my attention, some of the evidence that was being brought associated with this text amendment relative to the other 7 townships. I believe this is extremely also relevant to what's going on now because there's new members on the ZBA, and there's nothing in any of the testimony that was previously heard that said if you live in one township or the other, the health implications or impact of windmills are going to have any different impact if you live in Fairbury, Pontiac, or Streeter. So regardless of where those windmills are located, where you live, it doesn't matter. There was no testimony provided by anybody that the impacts of those windmills have any different effect. So the fact that it's not being presented, I think, is important. So I would request that judicial notice be taken of that record, along with the exhibits ultimately that are cited in that record.
Okay, and all of us have this document. We were provided with it at the beginning of these hearings. It's not previously been marked as an exhibit, so. Right, that's a little, yeah, I was going to find an old copy of it, because we just got the one copy, and that's fine. Yeah. So, and Will, at that point in time, you were on the zoning board.
I was.
You're a member of the zoning board, and did you help draft the report and recommendation?
That is correct.
So you're very familiar with this document and the content of it.
And to respond, I'm sorry, Council, didn't get your name, but specifically, the Illinois Administrative Code adopts the Illinois Rules of Evidence associated with these proceedings, so to imply that 201 doesn't apply to these proceedings, I think is wrong.
I too did some research and found that it's, I do feel that this can come in, we're looking at the exact same ordinance, the exact same sections of the ordinance that we looked at and made a decision on less than 6 months ago. It's a text amendment. It was a text amendment then, we're looking at another additional text amendment now. I believe the rules of evidence are flexible enough to allow this to come in and that this is relevant to our decision that this board has to again make and consider here. So over Mr. Rutherford objection, I would accept this into evidence as well as take into consideration what the documents are that support the facts and findings in the report and recommendation. Now, I wouldn't open that up to every hearing that has come before this board, and if this is the same type of hearing, it's a text amendment hearing. We've heard, many members of this board have heard hours and hours and hours of testimony at other wind farm hearings for special use permits. This is not for a special use, this is to amend the text of our ordinance in our county. And if we had not just looked at this and had not just finished this year, earlier this year, the relevance may be somewhat diminished. But in my opinion, the relevance is very high, that we should consider the work that the zoning board did like less than 6 months ago to come to the conclusion that we came to. So with that, does anyone have questions? Because I don't know that anybody's taken a look at this document prior to tonight or refreshed their memory on it, not knowing that it was coming in. Can you find it in your packet? If you have questions, you need to. Will was a member of the zoning board. You can ask him questions about the contents of this document. So Will, you might have to bear with us on that one. It takes a few minutes.
Just so I'm clear, you're admitting Gerber Exhibit number 1, correct? And you're also taking notice of certain other things?
As you requested,
The exhibits referenced.
the exhibits, yeah, that are
So make
referenced
sure
in this
that's clear.
document.
Yeah, this is.
It's right there. That's it. You got it. Well, I guess a question for you as I look through here. When we went through this the first time, there were a lot of differing points of views, and we really tried to weigh both sides along with evidence to support each of these sections. Would that be a fair?
Very much so.
Okay. I guess as we take notice on some of that additional testimony, Will, can you recall from those hearings the gist of a Massey testimony? When Mr. Massey come in and spoke to the board, and remind me what his capacity was.
As an attorney, you're referencing?
What, I mean, he was he there
He was in there in a legal capacity testifying.
representing?
The wind farm.
Okay.
And he was ultimately testifying as to relative setback requirements associated with the wind farms and the actual, I don't know if you recall, he provided the case relative to the duck pond and different classifications of properties and so on and so forth during his testimony, and cross-examined ultimately by the council during his testimony. There wasn't so much in relation to like legal opinion for health safety type of stuff provided by him, but some of it's outlined in the facts and opinion.
Something stuck with me, and you can tell me if I'm correct in my recall. There was testimony provided by Massey, a representative of the wind farms,
Correct.
that said that the proposed setbacks would actually not hinder the development of wind turbines, but rather it might require them to do a little bit more work.
When he originally testified, he tried to say it would completely prevent them from developing wind farms in Livingston County when he originally testified. He then took back his testimony on cross-examination and said the only thing it would require them to do is actually sign up more landowners to build the actual wind farms, which would require more work. So with the shorter setbacks would require additional landowners, they could still build the exact same farms. Keeping in mind, throughout all of this, every one of these is subject to waiver requirements. So regardless whether a setback's 10,000 or 20,000 feet, if a landowner wants to waive it, they're still subject to 1,500 foot setbacks if they want to be. So, and that's set throughout the ordinances as we discuss on the ZBA.
Okay. I did recall that correctly. You might remember, I'm trying to think who testified, maybe Mr. Slagle, in regards to noise. There was a lot of conversation with noise. There was also a question of potential property value degradation. And I think Mr. Slagle purported at that time that they felt, the committee felt that by increasing the setbacks would mitigate some of that real estate degradation or possible value degradation. Is that it?
Well, the problem with a lot of these as was testified to, the problem with these reports is most of these reports that are being provided come from real estate that's in Nebraska or other states. They don't really have anything to do with real estate around here. So it's very hard to compare real estate values here in comparison to something that's in Nebraska or South Dakota or something. And so that was part of the gist of the testimony with that. But
Any other zoning board members have questions for the one? Yeah, we gotta open it up to other people too. Mike, are you done?
I'm done for right now.
For right now?
Yeah,
All right,
yeah.
yeah, we're gonna come back. Okay. Any other, interested parties with questions, units of local government or school districts with questions for Mr. Herber? Okay, any other parties represented by an attorney? Any parties not represented by an attorney with questions? Okay?
Tom Classic, once again, White Township. Mr. Durb, I'm just trying to understand your opening. I didn't see this report. I don't even know what you handed out. But I believe you were saying at the beginning, correct me if I'm wrong, if I don't paraphrase this correctly, is health and safety doesn't matter where you put these. As far as whether it's in Sunbury Township, Dwight Township, Pontiac Township, that part does not matter at all.
none of the testimony that was
Yes, exactly.
was provided at the hearings, the health impacts, regardless of where the windmills were at, there was nothing that was provided that would vary in any township. So the health impact to any citizen, regardless of township, those windmills appeared to have the same impact regardless of where they would be located.
Okay, so
And that's why I felt it was important that it needed to be taken into consideration regardless of what township we're dealing with.
So that part will not matter at all. No matter where we put them, it's the same risk, the same health benefit or non-benefit.
That's how the testimony made no distinctions.
So then, do you have any opinion as to why we should have a different setback in different parts of the county?
That's not for me to determine. It's for the county board and the zoning board.
Thank you.
Okay, any other parties not represented by an attorney with questions? John?
I got a question. Well, how much discussion did they have before they put that waiver on there? Wasn't that the zoning board, I was on the zoning board with them when we done this. We discussed that waiver
For
to quite an extent, if I
probably an
remember
hour,
right.
probably an hour.
But it went over, we brought it back and forth over several meetings, if I remember
Yes.
right. And then I think we, as a group, decided that was one way to protect the taxpayers who only own a house and so many acres. It really has no say-so if, how close that can get if somebody owns a bigger chunk of ground next to it.
That's correct.
And that's also gave the windmill the opportunity, windmill people, to come in and exercise a waiver to build closer if they wanted to. And that allowed that person the right to make up their own mind whether they wanted it closer or farther away, if I remember right.
With for the individuals that went on the whole waiver situation, all the testimony with the health implications, there was nothing we were provided that ever justified, and you can see in the findings of fact and recommendations, where we tried to come up with a compromise between a recommendation, I believe I made of $2,750, and then there was a $3,250, we came to a resolution of $3,000. But there was nothing that, any health evidence that supported anything of just setting at 1,500. So how do you benefit both landowners that don't necessarily want them, the health of people in the county, that it could affect that the testimony provided, as well as help people financially that want the windmills around. And the waiver requirements, even for the 7 townships that are in question, and that seems to be the big concern, or the source of the testimony, is the financial benefits associated with those 7 townships. And it seems to be relatively unanimous from what I'm hearing. If that's the case, the waivers should satisfy the situations with those 7 townships, you would assume. And that's what we were trying to resolve passing the first ordinance. Now, whether that does that, because you can't talk to all 100 landowners or whatever of the 7 townships, but that's what we were trying to resolve, because when we got the results back, there was a pretty heavy favoritism for the windmills in those 7 townships, and those waivers can resolve that by people just signing the waiver. Here's the 1,500, and put the windmill up. And still protect the people that wanted the larger setbacks, and also taking into consideration the health and safety aspects of all the testimony that we heard. And it's stuff we discussed for hours upon hours in here.
I got a question. Well, what you guys based this on originally was the Pleasant Ridge thing out of Fairview, right? I mean, you went with a lot of stuff they said or not?
No.
No, I would say no to that as well.
No?
No.
So, where did you come up with actually what you call your 3,200, 2,700?
There was an acoustician that came to testify, 2 of them actually. One from the windmill company that came, UCLC hired a different one that came to testify. So there were 2 experts. An individual from the public brought an aeronautical engineer from the state of Illinois down here. So there was testimony from a bunch of different capacities that had nothing to do with, from what I understand, the Pleasant Ridge hearings at all. So,
But the other day we got a pamphlet handed out that,
keep in mind, I wasn't on the board during those hearings, so I don't know.
Gerald, I can answer that question for you, so did Mike and Rich. No, we didn't go back and rehash anything from Pleasant Ridge. If someone presented testimony, and we had some background knowledge on it in our own heads from what happened at Pleasant Ridge, it probably helped our understanding of what they were presenting at the text amendment hearing. But no, there weren't the thousands and thousands of pages that were submitted at the Pleasant Ridge hearings. Those were not resubmitted at the text amendment hearings.
There was some witnesses that were the same.
Yeah, there's, yeah, right, so Dr. Schomer did, no, he didn't testify at Pleasant Ridge. Yeah, so there is because it's the same basic topic, but.
Well, I'm just trying to put together, we've got Odell area with 1,300 feet, we got this new rule here with 1,600 some feet we're wanting to put through, and there's what you guys were talking about. So, when the Odell area went in, who set the setbacks for that?
That was in the
It was in the
ordinance at the
original
time.
ordinance. What? It was in the original ordinance adopted. The original one was probably 15 years ago. I remember with Rich and I, you and I, we sat in a courtroom, probably in this room, used to be a courtroom, and adopted the original wind ordinance for the county.
I remember that was 1,200 feet.
I don't know the
It
distance.
could have been, it was just a boilerplate that we.
It was,
Another county.
absolutely, it was a generic boilerplate from other counties, I think, that adopted similar.
So what I'm trying to compare is, these people wanted the 1,600 feet over here. There's been several rulings here. And what I'm trying to say is,
And a referendum.
are they asking something that's unusual? They ask for something different?
That's part of what you have to decide in this particular situation. Ultimately, it rests with you as to whether you should recommend that the applicant is.
That'll be part of our discussion.
Right.
Yeah.
And I think to add value to that, I think original, we had very limited information. I mean, we did the whole hearing process in maybe 2 nights.
Yeah.
That whole, I mean, there was just, it was a very new industry. So there wasn't near as much information as there is now. I mean, we get older, we get smarter. We get more time, we get smarter, we get more information available. You know, good experience, bad experience, whatever the case. So, and we had to start with something, and I mean, there was a lot of give and take even in that. There was some, because ultimately, a lot of it has to, still can't, the distance can be the distance, but they still can't pollute the noise at the noise level. So the acousticians, that's where they come into it and say, we define what a primary structure is and several things in this to clarify.
Okay, then I have a question. Then why did you choose 1,500 from any property line, whether or not there's a primary residence or not on that property?
You're asking Will?
Yeah, are you asking Will that
Yeah.
question? I mean,
How did you come up with that?
I didn't come up,
Okay.
just to clarify, like, all this stuff was decided in, what, 36 hours or something of
yeah, I
meetings.
don't remember.
So, and all that, I mean, the explanations of everything are highlighted,
Right, I'm trying to
Yeah.
catch up and go through all of it.
so,
I have been.
And Jim, this is something that we can also, when we
Okay.
close this case and we do discussion, these are looming questions in your head, we can discuss them as a zoning board
No problem.
at
I'm
that
sorry
point in
then.
time. No, it's fine, and if you have other questions for Will, go ahead, I mean,
I don't have any specifically for him.
okay.
That was one question that's been, I haven't been able to find yet. That's the only thing.
Well, like, I guess I have one. The county has presented 3, I would guess, what they feel are their most applicable assets to their hearing. One was a wind map that said Cayuga Ridge was windy. The next was Chuck opined that the density of the townships was less than elsewhere, by opinion. And then the county has determined that soil types it's not as good as soil. Do you feel that any of that would have played into the decision, any of these decisions from the previous hearings? I mean, how much value would have you put on 3 things such as that?
since I wasn't at the hearing, it's hard for me to answer. I'm guessing the soil type aspects have to deal with financial implications for the 7 townships. Financial implications are one thing to consider associated with the ordinance, on top of the health, safety, and welfare aspects. So I'm assuming that's why it was being offered. I don't know that though, because I wasn't here. So, but unless there was some kind of crop information, or income kind of information, tax information from the relative taxpayers, I think it's pretty hard just to base an entire decision on soil types alone. The density aspect I think is irrelevant, because regardless of the density, like I say, the health impacts, regardless where people are located, there's nothing to show anything any different. What was your first?
The wind map. The wind map that said it's windy on the ridge.
I'm assuming that once again goes to potential energy output and money-related financial situation, I guess. And if there's more energy output up there, maybe the residents get more financial impact or resources from it. But once again, unless there's some kind of energy output data or actual financial documentation that supports it, I think it's hard to make a decision based upon that. That would just be my opinion, but without being here, I don't know.
I have a question. Well, a few minutes ago, you said that there was an overwhelming favoritism in the 7 townships. And according to this document here, there was 2 townships that voted 60% and 1 at 63%, and the rest of them are all under 60%. Is that overwhelming?
Well, I think in comparison to how some of the other townships were, I should say, to quantify it. It's not, it wasn't like an 80 or 90%, you know, so.
Okay, any other questions from interested parties not represented by an attorney? Mr. Evans,
Thank you. Mr. Eber, thank you. You know, you haven't been at the prior hearings, but your earlier testimony discussed someone bringing all this to your attention. Who did that?
The videos that
Oh,
are recorded.
so you've been watching online? Have you been to any of the agriculture or zoning committee meetings in the last couple of years?
No, I've not.
We've been hearing a lot about waiver here in the last 20 minutes. Is that also a fact-specific question for a particular special use application?
Maybe.
I have nothing further. Thank you.
Okay. Any other questions from zoning?
One more. In any previous hearings or even through the previous amendment process, was referendum data ever considered as a point to make a zoning amendment or change?
No.
Anything else? All right, thank you all. Okay, so we're gonna take these in the order that Tom then checked folks in. So Lady Collages?
I'm not gonna testify anymore because the information I have is from past. I believe it's been reviewed in the past and I don't know that it's acceptable at this point.
I believe she can resubmit that.
I mean, since we don't know what you have, I mean, you can try and we can
All I have
play
is-
then.
Is 2 real estate persons, one of which was at the February 2015.
Okay, why don't you come on up to the front chair here and we'll get sworn in.
Because I was concerned about, you want me to swear in first?
Yeah, so can you state your name and then make sure you've got your spell right.
Mayte, Collages, Callejas,
Okay, and your address?
27575 East 3000 North Road.
You're gonna have to tell me what township you're from, area,
I'm sorry,
your address, but what?
Dwight.
Okay, do you prefer to be sworn or affirmed?
A sworn, please.
Okay, could you raise your right hand? Do you solemnly swear that the testimony you shall give in this case, now and hearing, shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
Okay. I'm not an expert, but I did some research on the internet, and I found two, which I feel are, I don't wanna say legitimate, but two people that presented what I thought was very good information regarding the depreciation of real estate, with the wind turbines being close to a home. But one of these persons was Michael McKeon, which apparently he did do, he testified for one of your, so I don't know, based on the information that we're getting today, if this is allowable. And one of the reasons I brought this in was because of the discussion of possibly not allowing that information, which I feel is wrong, and it should be allowed in. I'm not sure, some of the stuff that's been allowed in prior to this discussion would have been allowed in if we follow that rule.
Okay, well, I did take the step of accepting Mr. Gerber's exhibit into evidence, but the rest of the stack of exhibits that have been presented, I mean, other people have brought in documents they found on the internet as well.
Okay.
You can share it with us, it may or may not be accepted into evidence at the time, but you're free to state your piece and be heard on this topic.
Well, basically, they're saying it for me. It's just that I feel like the property values will drop if wind turbine setbacks are allowed to be closer, or the setback is reduced. That's it.
Okay, that's your major concern?
Yes.
Okay.
Any other questions? There's two. Yes, one.
Is this a whole,
Do you
That
have
is
one
the
labeled?
whole article from the Pontiac.
got it, and there's enough copies, everybody can have one,
Yes.
is what I'm getting at.
And this is from another website.
Thank you. Yeah.
All right, you want these submitted as two
Send me a
separate
bill
exhibits?
for it.
Please.
So we'll call the one page, well, it's one and a half pages.
It's an article, basically.
So that's Collegius Exhibit 1, and then the wind turbine and turbines of property value presentation is Collegius Exhibit 2.
That was there for the actual time. I was gonna say, glad to see it.
Okay, Chuck would like to know the source of this document.
Isn't the website on there?
Did you take it off? Was it
I took it
part of
off the
testimony from a
website.
previous,
I'm sorry?
was it a website where it was previous testimony that, previous?
No, this was just an
primary?
internet search.
Thank you.
Recent?
Yes, I just did this today. And I think they're fairly fair in what they're saying.
When you looked this up, did you have any idea when this presentation was done? Did it?
On
the
this
website
one?
that you were looking at?
You know, I'm sorry, I thought I had looked at that. I'd have to look back.
Okay.
I
It's
don't
not on this
remember.
presentation, no.
I'd have to look it up.
any zoning board members, do you have anything additional to add? Any zoning board members have a question for Ms. Collegius? Any units of local government or school districts? Parties represented by an attorney? Interested parties not represented by an attorney? Okay.
I got a question.
This can last further and then we'll go on and forget about you. Okay.
Hi. Did you know that there was wind farm development going on in Livingston County when you purchased your home?
I knew there was a development that's miles away from me. I did not know that it would be coming, or it could potentially be coming closer, no, I did not. I wouldn't have bought the property otherwise.
Okay, any other interested parties not represented by an attorney? Okay, let me ask the county first. Mr. Roger Schaefer, do you have any questions?
No questions, thank you.
Okay, Gerald?
Yeah, if I'm not mistaken, I think in your backyard, you've got some power transmission lines going through?
There are some, yes.
Did that,
Not in,
did that tell you not to buy
directly in
property
my,
when you
not
bought
in
it?
my backyard, but behind
Less
me,
than-
yes.
Less than a mile away?
Could be, I'm not sure what the distance is,
Would that stop you from buying your property back then when you did it?
no, because they're not on my property.
What about the high voltage and anything goes through them? Lightning strikes, there's,
The line doesn't run over my property, and they're not on my
are
property.
you saying a wind turbine's gonna be running over your property?
Yes,
You only own properly, what, 2
according
acres?
to you, yes, it would be, because of the size and the nearness.
What type of power lines are you asking about, Gerald? I'm not familiar with.
He's
them.
talking about,
The good transmission lines are running across there.
Okay, and you know that she's got them in your property?
Pizza is less than 3/4 of a mile of yard, I think. Am I correct?
Okay. Well, just a second, any other zoning board members with questions?
I didn't know we were talking about those, but okay.
They're in your,
Well,
you're in your
wow.
pamphlet.
Well, I didn't wanna take bits and pieces out. I'm presenting you the whole presentation, but my concern is with the setback of a wind turbine.
Yeah, I've got one question. Do
Yes.
you know where that survey was taken?
In Wisconsin, and I believe it was done in 2016, but I
'Cause
can
that's-
check and let you know if you wanna know.
I'll back it up to an interested party not represented by an attorney, Mr. Kolasik.
How far are those transmission lines from your house?
I don't
know.
know.
You know how many volts those transmission lines carry?
I do not.
How tall is that tower?
I have no idea.
Does it have an aviation light on it? In other words, is there a red light or a white light
No.
that strobes?
Not
No.
that I'm aware of.
Therefore, it's under 200 feet.
Anything else? Mr. Kolasik?
No, ma'am. Thank you.
Okay, last call for questions for Ms. Collegius. All right, thank you.
Thank you.
All right. Ms. Campbell, you're on the list as the next individual to testify.
At some point in time. I sent my counsel. It's right.
Here, you can have mine.
Oh, no, that's okay.
Are those going on the website?
Pardon me?
Are those going on the website, Chuck?
They haven't been, no.
Okay.
I just, at some point, wouldn't mind it, but
Email me.
There you go.
I'll try to remember. But
Thank you. I have 3 exhibits.
Okay, well, state your name and address for the record.
Judy Campbell, 28816 North, 800 East Road, Manville, Illinois.
Do you prefer to be sworn or affirmed?
Sworn.
Would you please raise your right hand? Do you solemnly swear to tell that the testimony you shall give in this case now on hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Okay. My second exhibit is actually a subset, some pages from the soil survey map that the county has in evidence. And I want to discuss, so I don't know if that's my exhibit or yours.
Yeah.
That big fat book? Yeah, the whole book was put into evidence, correct?
No, we did not put it in evidence. No, just excerpts.
Oh, okay, I've got more excerpts then.
Excerpts.
Okay, so I've marked them already for you. Okay, my first exhibit, number 1.
Hey, just a second, bear with us a second while we get, everybody gets copies of file on. Mr. Redling Shaver, did you get copies?
Yes, I did, thank you very much.
Did you, Mr. Lance?
I'm fine, thanks.
Well, this is just something I downloaded to remind you guys, or you, first of all, I'm honored to be talking to you again. The zoning board, I'd like you to consider the fact that in the township next to Nevada Township, there is a nature preserve there, and the border of that nature preserve is 1 mile from the edge of Nevada Township. So in addition to 16 homes that are within a mile of that boundary, there's also a natural area. So I know the IDNR, whenever they do whenever there's an application, they review the application for a wind farm and they make recommendations. And they have noted in the past that habitat can be affected by the presence of these termites for some species. So I don't know if I just wanted to note that. The second exhibit, okay, the first page says prime farmland on it. That's from that soil survey book, and it discusses what prime farmland is. And on the second page, it indicates there's a list of soil types that are considered to be prime farmland in Table 5, prime farmland. And I've attached Table 5. And you look, now if you recall, the soil map for these 7 townships, a large area of it is called Bryce Swigert Association.
Did
So
you
Bryce,
submit that to us?
no, you have it. The county
Yeah,
did.
we've already got that from
Yeah.
us.
Yeah. The county did. And so basically, there are 3, what would you call, soil associations. Number 1, number 5, and number 6 in these 7 townships. And particularly Bryce and Swigert, if you look on this table, about 1, 2, 3, 4, 5, 6th, 7th, and 8th soil types are called Swigert, silty, clay, loam. And that's in the list of prime farmland. And then Bryce is a little more than halfway. It's number 235. Bryce, silty, clay, where drained. And as far as I know, from what I know about field tile, that soil is well drained wherever it's possible because people want to be able to farm it. So So that would be that would fit into that area, kind of yellow area. Okay, for number 1. And additionally, number 5 and 6 would be Elliott, Ashcombe, Reddick, Andrews, and Simmerton Association. And number 146A, B, B2 and C2 are Elliott. Number 232 is Ashcombe. Number 293A is Andrews, Sloan, Simmerton, and 294B and B2 are Simmerton, Silt, Loam. And of course there are many other soil types, but I think this exhibit should highlight the fact that this is prime farmland according to the USDA. And nowhere, when I studied this book, I couldn't find anywhere where it said a lower number meant lower quality in this map. You know, it didn't really say that. So maybe you guys know more about soil types than I do, but I couldn't prove it based on what I investigated. Third exhibit. Back in, I forget what year it was, probably 2012, at the October Ag and Zoning Committee meeting, Iberdrola submitted its post-construction avian mortality study to the Ag and Zoning Committee. So the county has the full report, and I've given you just the pages that relate to bats. I don't know if bats have been in the news a few times as far as having threats to their existence because of white nose syndrome, and also now we've discovered that bats are killed by the termites, especially the migrating bats. And you may have seen, some of you guys who were on the Pleasant Ridge hearing may have seen the recommendations from IDNR as to how to do the how many years to do the post-construction mortality studies, but for this particular wind farm, the county required 1 year of post-construction mortality study. And in that year, this is the wind company paid for that study, and then they published the results. They reported 6.3 bat fatalities per megawatt per year. Well, there's 300 megawatts, so that's 1,890 dead bats that's been admitted to by the wind company. And now we're into enough years that we've probably killed over 13,000 bats. So it accumulates. And so, I mean, I could have talked to you about birds and a lot of other things, but bats are pollinators. Bats are mosquito eaters. They are beneficial to human beings in many ways. And I just, you know, it's not just human beings that are affected by these termites. So that's my testimony.
Any questions from the zoning board? Any questions from units of local government or school districts? Parties represented by an attorney? Interested parties not represented by an attorney? The county, Mr. Rosen Schaefer?
No question, thank you.
Okay, I have one question. With this one here, how does this relate to the text on the city? Okay,
Whoa.
I won't answer, that's fine. I didn't, that's fine, I won't ask.
You're retracting your question?
No, yeah.
Okay. All right. Any other questions?
Chairman, can we rule on that?
If he retracted, it'll almost like.
Okay.
If he's gonna stick with it and say, leave the question on the table, I'd address it.
He had his opportunity.
Mr. Redenchafer, you mean?
Correct.
Right.
Representing the witness.
It's been a blurred line.
There's no blur.
Yeah. Any other questions from the zoning board members?
No, ma'am.
All right, thank you. All right, anyone else with testimony tonight? Who would like to provide testimony in this case? All right, what time do we have? 10 after 9?
This is where the brief presentation by county staff, so that, publication exhibits.
Okay.
And also, planning commission final report must be submitted because of that.
Oh, yeah, so,
What?
yes, you know. You wanna, now?
No,
For planning commission.
it's gotta come in from somebody else.
Yeah, I mean, yeah.
Chuck.
Check on this, you can do that.
No, he's a witness.
You can, it can still be submitted. You typically take that into consideration.
Let me just add, I mean, is the planning commission report always part of
It is.
proceedings?
It's always been submitted before in the past. It was done in the last text amendment hearing.
I mean, I certainly refer to the chair, the zoning board of appeals, but if they're always submitted as a matter of due course, that's,
Do we have the commission report in complete
Well,
form,
it's-
and who drafted it?
It is the minutes, when we started this procedure, I presented you a copy of the minutes from the planning commission. You requested, at that time, it had not been approved by the planning commission. The minutes were submitted to you as a report. Subsequent to you asking that question, the planning commission has met, and they've approved that set of minutes. So I was gonna provide you the copy of the set of minutes from the planning commission approving that set of minutes, is what that exhibits.
Okay.
Again, that's something that you would request.
I'm fine with taking the document, I guess you typically give a summary to us, and maybe in this case, yeah, I don't know who else would provide it, but in this case, maybe we just take the report, we all read it, so we're not gonna conclude this meeting
We
tonight.
weren't there though at that. To read it is moot. I'm not saying Tom can't give it to us, but Chuck cannot. He's a witness.
Right, so that's why I don't want the summary or Chuck's perception of what happened at the meeting. If they reviewed the minutes, that's about unless we want the transcript, aren't those recorded?
I don't, so I'm trying to record that one.
I mean, and then in this case, this is the best that we got.
And again,
And we do need to hear what they, at least take into consideration what the minutes that they approved.
right. And this is something you asked for.
Pass them out. Good guy.
I believe the due process here is completely, I've addressed this prior. He can't play multiple sides, you guys.
But did we ask for this?
Yes,
Right?
we did.
We asked prior to him becoming a witness. We asked, all of a sudden he became the lead witness for the county.
My opinion is that we don't need to mark it as an exhibit, but you can consider it, to have in the past. You asked for it, it's being presented.
I think we should take the document. I don't necessarily need you to provide a summary or a typical overview like you usually do.
Let me repeat, you already have a copy of the minutes written on. This is just a copy of the minutes where they approved that sub-minutes, just to show you, answering your question, because you wanted to make sure the planning commission did approve that sub-minutes as they're written. So that this document going with this, you already have the other sub-minutes, it's already in record. This is just proving it was approved by the planning commission to do that. That's all this is doing.
Okay, we can figure that out from reading. Is that the document or not?
These are.
This for us over here.
Yes. It's just the opening where they approve the minutes from the, approving minutes from the June 5th meeting, that's all that is, because you already have the June 5th minutes. And they were passed out to you previous, one of the initial meetings.
Just 2 extra copies here.
These minutes themselves have nothing to do with that case. This is just approving the previous minutes we handed out to you.
There's no wording in there.
The wording is simply on the first page under approval minutes, the June 5th minutes, mentioned by the chairman, Mr. Slade will move, second by Mr. Horn. The minutes be approved as presented, and you already have the copy of the June 5th minutes.
I think there's a exhibit, Exhibit 10.
If you guys would prefer, I could testify quick and enter them. I'm on the regional planning commission. I can answer questions.
That works.
Slightly number one, right?
I just have my one copy of the minutes.
Which ones do you have now? You have the actual minutes?
These are the ones we
Or do you
approved
have-
at the last meeting.
So the approval of minutes, the small section, the
Yes.
document Chuck just handed out.
July 31st.
July 31st, it's up there in the head. Filed on July 31st. You just handed it out.
Yes, this is what I have.
I'm just asking John what he's. That's what
Oh, that's the minutes of the meeting when we approved it? Okay, this was the minutes that we approved of the actual meeting where we approved the ZT3-17. These are the minutes from the.
Right, this is already an exhibit.
Okay.
This is what Chuck says minutes of June 2017.
Okay. And just copy that?
Yeah. We'll just make this slightly lower.
John Slagle. And we're at 308 East Merlin, Beth Lane in Fairbury.
He sworn or affirmed?
Sworn.
Raise your right hand. Do you solemnly swear that the testimony you shall give in this case now and hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
So help you God? so this document that's, that is in the heading, the third line down, says held on July 31st, 2017. This is the document you're submitting as an exhibit.
Yes.
Okay, so we're gonna label this label exhibit 1, you already did that. Okay. Okay, can you tell us what this document does?
Yeah, this is where we approve the minutes of the meeting.
Did you have the opportunity at your meeting to review this?
Yes.
The minutes from the June 5th meeting?
Yes. And at the June 5th meeting, if you care, basically we were presented with the same thing Chuck presented here at the beginning of this hearing, which was the paper that had basically the blurb about the wind and the soil types and things like that. And then we discussed and we looked through all the changes that were proposed. If I remember right, like we talked about some of the setback language that Chuck then mentioned that and talked about that. Pretty much agreed with what we said.
Out of my own curiosity, do you get all the exhibits that typically come in at a hearing here on this regional planning commission?
Really, we had the letter, and I guess you had all the exhibits in it. I have it in my folder, I can dig it out.
No, it's okay. I'm
But yeah, it had
curious.
the soil type map, and I think the wind map and some of the maps. It didn't have any of the referendum results. Or did it? I forget. You want me to grab it quick?
No, that's,
They have to be looking at similar, or basically the same thing to give a recommendation to us.
Yeah.
With
Right.
that.
I would say we had the same packet that you guys had the first night that Chuck gave it, Chuck handed it.
okay. Is that typical in other cases that you look at too? I mean, this is just kind of a regional planning commission question overall.
Yeah, I would say
It's
so.
not about the text of it.
Yeah. I think, as far as I can get the distinction between the ZBA and the Regional Planning Commission is, the Regional Planning Commission is more about, does it meet the requirements of the special use permit or not, of the comprehensive plan, if it meets those conditions and fits in with the county. Not as specific as you guys get with the zoning.
Alright, any others on
Yeah, I
this?
have a question.
Yep.
Second page, 1, 2, 3,
Of the
4,
actual
5,
minutes or
6,
the-
7. The first draft, county 10, the non-approved minutes.
It'd be the June 5th.
Yeah, regardless, I think it's gonna reflect the same. Can you tell me, the line reads, it was then noted that would apply to just 5 townships. What 5 townships were discussed at your meeting?
Okay, this, I can't find exactly what you're talking about, I remember that. It was basically, they were saying, if you have the difference between the township with a smaller setback and the township with a larger setback, and you have a house in the larger area, a house in the larger setback area, should it get the larger setbacks even if they protrude into the smaller setback township? And then the consensus was that it should, the house located in the township with larger setbacks should get their larger setbacks even if they protrude into the smaller setback township. And then that's where we said, I think that there was only 5 townships that was an issue with.
How could you, what was your basis behind allowing an adjoining township home to have a wind turbine further away, but yet if they're in a township, the health, life, and safety are diminished by just simply living in a township? Is that what I understand?
I don't think we had that discussion. It was if we had these, if it was more from the approach of if these townships had smaller setbacks and these had bigger for whatever reason,
Okay.
then if this situation occurred on the borderline, how should it be dealt with? And we wanted the language to reflect that the person in the larger setback area should get their larger setbacks.
And I could find value to that in the comprehensive plan? The comprehensive plan would help me get there? I mean, you said you considered the comprehensive plan.
Yeah. In that case, no, we didn't.
No. So just so I understand,
Mm-hmm.
in the 5 townships, if you have a house adjoining you get the 3250.
Correct.
But if you're in the township over, we're trying to get you 1,600 feet. And based solely on where you live is the deciding factor for this.
Yes, assuming the townships had that difference, we were looking for language to be added to give the larger setbacks to that person in the township.
But you didn't have a discussion about this.
No, we basically took the document that Chuck gave us with the proposed changes to the text amendment and said, if this is being implemented, what are the issues with it that we should address? And that was one of the issues that we tried to address. We didn't really question the validity of separating out the township.
Did you discuss the validity of a turbine within 1,600 feet of a home?
No, it was really just if we're doing this text amendment, what are the issues that arise?
And the overall consensus was this did fit within the comprehensive plan by allowing 7 townships to, and the rest of the townships not to.
I don't think we related that to the comprehensive plan.
Because I've been trying to figure that out. Early on, I asked the comprehensive plan, and I couldn't find it in there either. Okay, so it was used in consideration or was not used in consideration?
It was not in this case.
Okay. Referendum data, was that used in the attempt to change zoning?
Okay, I'm just talking about our discussion we had. I'm not sure if it was in the evidence or the papers that Chuck handed us or not. But in our discussions, I don't. I'd have to refresh the minutes to see if you don't mind.
Go ahead.
Okay, it seems like the referendum question was presented by Chuck. Yeah, that's basically.
So the referendum data was presented, and that was a consideration.
It was presented, but I don't think it was a consideration. Our consideration really was if this language is proposed as the text changes, what issues do we have with the language itself?
So you didn't consider how the language changes would apply to the comprehensive plan?
No, I wouldn't say we did.
All right.
Go ahead.
So my question is, you said the referendum data was brought up.
I don't know if it was actually discussed. It was handed to us by Chuck.
Okay. But the referendum was a countywide referendum, correct?
Yes.
So the whole county voted on it for the whole county, am I right?
The whole county voted on it on a township by township basis.
Okay.
And the results were tabulated by township.
Okay. I didn't know that, so.
Yeah, we didn't question the intent of the text amendment, I guess.
So then I'm confused, what do you do?
That's a good question.
Well, not the answer I was hoping for.
Honestly, there's overlap. There's a lot of overlap between that and the ZBA. And I don't know the exact distinction. It's more, it seems to me like the Regional Planning Commission is more like, does this fit? Should this be proceeded with as a recommendation? Not really, should we approve or deny this? I don't know.
Based against,
I've been
against
there.
which standard?
What's that?
Based against
The
which
comprehensive plan.
standard? But you told me you didn't consider the comprehensive plan when you made these decisions.
On this night, when we did this, we were basically focused on how it crossed township lines.
Oh, really just how to apply it, not
Yes,
necessarily
right. Assuming you're going to do this,
assuming it's
what
happening
issues are gonna arise from applying it?
when you apply it.
Yeah.
So your recommendations to our board to approve it, isn't,
I think,
isn't that what we did?
I
Yeah.
thought that's what we were getting, but if it's just that, yes, it could be applied, and it could be applied to fit the wording, cause I wondered why there's the comment in here, and I'm looking at the second page, and, where's the one in here? You didn't like the word setback, and it, to potentially propose a different
150-foot
for setback,
increment or something.
is what I kinda keyed in on before, and now I'm not finding it quickly, but if you guys are looking at how it can be applied, and if it makes, the actual language makes sense, because somebody could read it and interpret it and apply it in this setting, then I see what you're recommending, but it's essentially not what we all thought you guys were sending recommendations to the zoning board.
oh, they're talking about that's the 150-foot setback around the house for the sound measuring.
Yeah, let me find out what that
It's
is.
right at the end of on page 2 at the end of the paragraph, the top of the paragraph.
Yeah, it's like 4 lines up from the end of the end of that first paragraph. Again, dialogue took place about the awkwardness of this language.
Right.
And I thought, why is awkwardness of the language? What's that really telling us? But now I understand, if you're looking at how to apply it, if the language is awkward, it's very difficult to apply it in a practical setting.
Right.
That's what you guys are looking at.
Yes.
Okay.
Yes, basically we're looking at if you had the intent of the text amendment, what are issues that would arise, and we didn't question the contents of the text amendment, the 7 township division.
So our comprehensive plan basically says if we can apply any language in an ordinance, we can draft anything. The planning commission's gonna tell us, draft any, go, move forward.
I
Go
can give
ahead,
you my
'cause you can
opinion
apply
on
it.
that, but in this case, we weren't applying the proposed changes against the comprehensive plan. When I said comprehensive plan, I just meant generally that's what the regional planning commission does. And that's just my take on it, I don't know.
Okay. It's my interpretation of what you guys did was take basically the same evidence, but you're bumping it up against the comprehensive plan, and it fits and makes sense, not in an application setting, but in a overall
Right.
law for our county.
Yeah,
It's just a different mindset, I guess I would have. You guys are looking at a very small use of the language then.
yes. I think we looked at the reasons Chuck gave in his paper, and we said that was plausible for a reason that these areas might want a different setbacks. And so if they do, what issues are going to arise? we assume they wanted those setbacks.
Any other questions from the board? Any units of local government, school districts? Parties represented by an attorney? Any interested parties not represented by an attorney? Any questions? Mr. Colastic?
Couple quick clarifications, and pardon my ignorance again. What is the regional planning committee? What region does it represent?
The county.
It's just Livingston County?
Yeah. Basically, to have, my understanding is, in order, if you want to have a sort of a comprehensive plan for your county, then you have to have a regional planning commission. And so that's its purpose. It's sort
Who
of
makes up the commission?
the planning committee.
Yes.
It's made up of 10 people. They're appointed.
By the county board?
Yeah, the board chairman.
And the comprehensive plan, how long?
Actually, the board, yeah. The board approved it.
How long do you look out on your comprehensive plan? How many years are you putting together?
I'm relatively new, so I just.
Like I said,
But it's.
I'm asking
the plan-
because it's out of ignorance.
Yeah, the plan was last updated 2012, if memory serves me. 2004, I would say.
Okay.
She knows.
Thank you. Thank you, ma'am.
Okay, any other questions? I can't tell the, Ms. Campbell.
So, are you aware whether the comprehensive plan is available to the public on on the county's website?
I think you'd have a hard time finding it.
Okay, when you were appointed
Mhm.
to the Regional Planning Commission, and this may not be relevant to you guys, I don't know, were you given a copy of the comprehensive plan?
I don't think so, but I had one from the
Yeah,
previous
yeah.
wind farm hearing.
Okay.
Can't remember, sorry.
Okay, any other questions by interested parties not represented by an attorney? Mr. Redley, Chamber.
No questions, thank you.
Any other zoning board members? Questions? Thanks, John. Publication.
Yeah, I figured we'd do that.
We need to go through the list of it, we're gonna do that in an open meeting.
We usually Chuck presents them, they're marked, and then they're accept, that's the question. Is there a problem with Chuck taking care of exhibits?
What do we need Chuck to do with the exhibits? We got them marked, we.
I don't have them marked here, they're right there.
Oh, so we have more exhibits that need to be finished?
That's where I'm coming from.
Oh, okay. So who, like, are you testifying again? What are we doing here?
However you want to classify that.
I don't know what this is. You obviously know what this is, so I don't know what's coming, so you're gonna have to tell me what this is about, and then I can discern.
The purpose of ordinances, statutes require that proper notice be given to the CBA hearing. And it's going to come to check as its zoning administrator, to make sure the notice is given. They are typically marked and accepted as evidence, unless somebody raises an objection.
Somebody else from the county,
So, is this for all of them, all the continuations, or they're separate?
No, basically this first hearing, remember how they are recessed and reconvened? So we'll give notice of the first one, and then you don't have to give notice after that, as long as you recess and reconvene.
Okay.
Now, remember the last time, text amendment, we had to be published because we didn't have a form, so we had to recess and reconvene.
I just don't remember the editor's exhibit, so if that's all we're doing, I'd have to take a look at it. I'm assuming it's just the notice that went to the paper.
God, pass them out. Jeez, guys.
Well, I don't recall doing this in other hearings, so I just want to make sure. I don't know.
We did it at the last hearing, the last text amendment hearing.
I don't see a problem with accepting this as evidence, or accepting it as an exhibit.
Was there?
We have to do it. Okay, sure, go ahead and hand it down.
No, I show now, time for the closing statement.
Alright, and then we'll go through the list of exhibits after.
Well, maybe we should do that now, before we go any further, so people can. Why don't we do that?
Well, it's 20 to 10, so I'm not in favor of starting closing statements tonight. Maybe they'll be quick, maybe they won't be, but we have the list of exhibits that we can go through. I'd like to just go through the list of exhibits, determine what's in, what's out, and call it a night. Are the zoning board members okay with that?
All good exhibits?
Yeah, and not starting into closing statements at 20 to 10.
I'm getting tired.
I'm getting tired too. Okay, so that's what we're gonna do. We're gonna go through the list of exhibits. Make sure you've got them all labeled and what we accept into evidence.
Okay.
So, zoning board members, if you have your stack, I would follow along so you know you've got every exhibit, you've got it labeled, and then if for any reason you decide not to accept one, you can note it on your document. And then do your calendars out, so you've got it set. Regular meeting.
It'll mark the publication in the group.
Yeah, county executive seen it was already marked.
Okay.
Yeah. Yeah, let's just take them in the order that we just.
Okay.
I'm sorry, I can't hear back there, so.
Sure.
So one was just the original packet that we had, report to planning commission and copy of case number.
There's no more testimony to be provided with if there's anyone that is not interested in the list of exhibits, that's all substantively that we're doing here, and then we're gonna recess. So if anybody wants to go, feel free. I just don't want to sit here and be bored. Okay, take a quick question.
I'm waiting, you're gonna have,
Pardon me?
are you gonna be, getting?
Do you want the next meeting date?
Well, Tom reminded me that we already have the next meeting date of October 5th. It's our regular evening, and I don't see we have we have no other matters.
Okay.
So at this point, it'll just be for this. So, and it'll be 7 o'clock, is our normal meeting. Okay.
County exhibit number 1, report to planning commission with copy of case that was ZT-3-17, May 27. Admitted.
Admit this.
Okay. Number 2 is specimen ballot, general election, November 8th, 2016.
Okay.
And number 3 is county clerk records for county, township, and farm, advising their further results, counties and by township. Okay. County exhibit number 4 is Illinois annual wind speed.
Yes.
Okay. Number 5 is watershed and rivers.
Yep.
Number 6 is hydrogeologic report. Number 7, cell survey. Number 8 is population figures from county clerk and tax studies.
Yeah, if you wanna say an excerpt of this survey.
Okay.
It's not the whole.
Okay, excerpt.
Oh, sorry, you have labeled as.
Population figures from county clerk and tax levies. Just my wife wondering if I'm gonna be home today. So, number 8, population figures.
Yes.
Right. Number 9 is exhibit prepared by check showing location of wind towers with relation to area which is subject of this text amendment. Number 9.
Exhibit 9 is, doesn't, have a title on it, so that seems to fit. Yeah.
Oh, yeah. Okay.
Well, I also leave the depiction of gap in Broughton Township existing non-tax structures.
Which
Is that an
sorry,
accurate title?
Which is better, hers or mine? Okay. Well, just, admit number 9.
Yeah, you're both correct, it's a map and it shows the blank area between the existing farms that are there. So it's the gap.
Yeah, that's what I thought, that
It's
it's
the gap that it's showing,
Right.
so you're both.
Okay.
What did you call it?
Location of wind towers with relationship to area which is subject to text amendment.
Yeah. So you're calling it the area, she's calling it the gap.
Okay.
Well, the numbered items in this, they're not wind turbines, are they? Or they are they?
No.
Okay, so they're not wind turbines, they're not cited, so I would call it the depiction of the gap in Broughton Township.
Right.
Actually, between wind turbine farms.
Yes. Right.
You want my wording?
Yeah, your wording works.
Turn sideways.
Okay. But that's agreement though, right? Number 9.
Well, I mean, if you're flying through, there's a couple that I would go back and review, if I could admit some internet stuff, then there might be a couple that material we don't admit.
Number 10, regional planning commission meeting minutes, 5/17.
Yep.
All right, number 11 is Nordex, following turbine parts, 500-meter radius.
Okay.
All right, and then number 12 is tower-based dimensions. Okay. The next thing I have are UCLC. Where do you have that?
County Exhibit 13,
Oh, right. Yeah,
certificate of publication.
Yeah. Is that in there?
Well, if we're gonna, okay, well, let's go back to Exhibit 11 and 12. Because we've got documents that were evidence from Pleasant Ridge.
Right. Similar.
I have it written on here, someone wrote it on here, I didn't write it on here. Setback recommendation from exhibit submitted at Pleasant Ridge hearing. So if we're sticking with documents from prior hearings, these are not coming in.
Okay.
That's because it was the Pleasant Ridge special use permit hearing. not the text amendment.
I show UCLC minimum setbacks for GE, Vesta, and Nordics.
UCLC?
Yes.
Back during the hearing for the window.
Oh, right.
No, that was here.
This is
Yeah, it was
Hamilton
here,
County
it
Exhibit
was here, but it was
11.
originally,
Okay, I mean, we have the right to bring exhibits. We brought exhibits. We're here to be questioned about them. And I think the county has the same issue. Just because it was in a prior hearing, if we have someone who's here to testify, they're still able to testify to it. You can't just say as blanket, if it was ever brought before, you can't bring it back. That's just ludicrous.
Well, according to Tom's research, though, if the person...
That's not, wait, first of all,
I was talking about judicial notice.
yeah, and we had someone here to testify. John had people here to testify on 11 or whatever it was. And
They were subject to cross-examination.
yeah, and the county, honestly, in that prior hearing, was able to subject to cross-examination as well because they were a party to it. They had the right to cross-examine in that prior hearing. So, I mean, I've stayed out of this, but if you start going after our exhibits, we're gonna have a full-blown discussion. Because no one objected at the time we submitted.
Exactly. Just like nobody.
Let him in.
He's talking about minimum setbacks. This is number 1. And the other one had to do with sound.
Oh, so you moved on. Okay, I was talking about county exhibits.
You're talking about 11 and 12.
Yeah, county
Right.
11 and 12, not this.
But we're still standing on the same basis though.
Right.
Are we or aren't we? If it come in before, can we have it again?
I believe you did it anyway.
Right.
So all I'm asking is fairness to have ours in, yours is coming up.
And I think we should do 11 and 12, and I also believe we should let in UCLC, both exhibits for UCLC.
Are those ones you went to next?
Are you
Yes.
talking about 11 and 12 being UCLSC or?
No, 11 and 12 counties should be admitted.
Right.
Okay, and I'm also saying UCLC exhibits 1 and 2
Oh,
should be.
these here.
Yes,
Okay. So you were always talking about these two?
when I was talking about
No,
you.
I wasn't, so there was a
Confusion,
confusion, yeah.
okay.
So,
I thought we had settled those issues, and I was moving on to the next grouping of,
Well, now these are clearing out.
right. So that was my misunderstanding.
And 2 was not part of UCLC, was not part of the prior hearing. This is
right,
not.
and I don't know that this was either, or at least it's not presented and written on the document as from a Pleasant Ridge Legal.
I took it not to be necessarily from the Pleasant Ridge hearing,
So that's why
that's why I had no problems with it.
What about the county soil survey that was presented with the preface that said from the Pleasant Ridge Wind Farm hearing
But
in the
Chuck was
first
here-
evening?
He was here to testify,
Fine,
and subject to cross-examination.
fine.
And therefore, I believe it should be admitted.
the soil survey we're talking about now?
Yes.
Not this.
No.
Well, and this, is the soil survey submitted at Pleasant Ridge?
Yes.
I don't remember.
I don't recall.
The preface was, I look back in the transcripts, or listen to it, it was taken with the preface that said this has been previously submitted in previous hearings, da-da-da-da-da, I'm offering it again. Something along those lines.
I believe it should be admitted.
You talking about soil survey?
Yes,
Yeah,
under 7.
yeah, I agree with that. I was just specifically concerned with 11 and 12 because it's recommendation submitted at Pleasant Ridge hearing.
But it was submitted at this hearing via this witness. Okay, my concern with bringing in evidence from another hearing without anybody to testify would be subject to cross-examination. And Chuck presented and was subject to
So
cross-examination.
any evidence that was brought by an applicant or a witness, but not brought in from a board member or
Right.
attorney or whoever's is not.
Right. So Chuck, again, with this exhibit, was here, he presented it, he testified in support of the exhibit, and therefore I think it should be admitted.
Okay, I'm uncomfortable with it, but I will.
Did he
I don't
testify
think
as an
any-
expert
and it's
witness
gonna-
on,
Right, these are documents that Chuck prepared.
yeah, can
But
he prepare a?
he testified there was no objection raised at the time,
Correct.
Okay,
and therefore,
let that stand.
okay, so 11 and 12 are in.
11, 12, 13. And then you did UCLC, exhibit 1 and 2.
Right. Again, there was testimony presented at this hearing, and it was subject to cross-examination, so.
I'm not questioning, I'm just trying to make sure we're in the order, what are we talking about? Or where are we?
Where'd you have the 13? Did you?
So the certificate of publication has just been tonight.
Oh, over here on this one. All right.
Yeah, no, you should, because that's, we'll reference it when we discuss.
We're going by what we were given at guidelines, like here we're next with these, right? They should match them on. Is that how you're doing it?
UCLC, maybe, it's all.
Sorry, say what?
He just wondered what the order was gonna be.
So there's one, in there 1 through 5?
For what? What are we talking about here?
It goes along with the UCLC.
There's 2 exhibits.
There's 2?
Right. Exhibit 1 is setbacks, and exhibit 2 is the sound study, the impact of movement of our location, and it has multiple pages. And the difference in each page is movement of 0 feet, movement of 50 feet, movement of 100 feet,
Right.
150 feet, yeah, 250 feet. It's specified in it's all part of the same exhibit.
So these are next note in our, behind our count.
Right.
Yep.
And I guess the next one would be tri-point, first one exhibit.
Yeah, group exhibit. Number.
Right. That's the way to. Says evidence for the development of separate distinct units for the development of the problem, so, right. So, and what we did is we made that one exhibit with different pages. Correct.
So there's 5 there, right?
Right. And then, classic. Exhibit 1 is lightning bolt information.
Nine of them, I think. No, 10. 11.
Yeah, I show 11.
11.
They're all in.
I don't see any reason not to.
Can you read that chicken scratching?
Huh?
Can you read that chicken scratching?
Mine? Yes. You sound like my mother.
I was an English teacher.
So was she.
We're back. Order exhibit 1, which is already in evidence.
Okay, we don't, did you able to copy that, and you had it already, pack it up. You can get copies.
That's what I marked. for identification purposes. And I thought you had already approved it.
What are you talking about?
Yeah,
Gerber exhibit number 1, represented there.
the report and recommendation document from the prior text amendment.
You need to see it?
What's the date on that?
What's the original one?
Over here. It's right here. So that goes
No, that's not it.
I think you had it in your, you set it back down.
That's original. That's the other one.
Yeah, you
Good with
set
the
it
other
back
piece.
down.
You were doing good.
Mr. Gerber had it earlier this evening, you were looking at
You
it.
got it.
That's it there.
So this is number 1?
Gerber.
Gerber exhibit number 1. And I got Judy Campbell. Exhibit 1. Has to do with nature preserves. I think that should be there. And exhibit number 2, soil survey should be omitted. But I think that exhibit number 3 should be excluded. It's not relevant. This is information from a special use wind farm siting hearing, we're involved in the text amendment. So I would suggest that would be denied.
Well, I think it could be admitted. She was here to ask for the answer questions of it. I don't know. Any relevancy, that's something that the board, we need to consider. Maybe you don't put as much relevancy on this document as others, but
The amount of weight to be given.
the amount of weight,
Okay.
So it's in?
it's in.
Slagle exhibit 1.
And what do you want to do if we just, you're saying that they should not be accepted?
I thought we already took care of those. I thought they were all here.
Well, we had, what, two? Was there two?
There's 2,
Yeah.
the
Oh,
1.5
I'm sorry,
inch.
Yeah, the paper. And the Wisconsin property
Okay, these have to do with property value, and again, I think they should be denied because we're talking about a text amendment, and this is an issue in a special use permit. Citing here, different standards for text amendments as opposed to, special use hearings.
Okay, well, again, we put everything else in, she was here to answer questions. I would say that these go to the weight, consider what weight you would give these documents when we make our decision. That's all the exhibits that I've got.
Did we take care of cycle number 1?
Yes, you did that, I think the ones too.
So the answer is yeah, I mean,
Yes.
okay. Okay,
Didn't Mike have an exhibit for the first night?
Mike?
You had a question on it, and that's,
I thought he submitted it as an exhibit. I thought he said this is county exhibit 1.
Are you going forward with that line of questioning we had from before?
Maybe.
So is he a witness?
Well, that's,
I can ask any question of any witness at any point in time during the proceeding. Mr. Flott.
okay, and we can, I mean, and a lot of times with Mike, he has a lot of knowledge on plumbing issues, and on other zoning cases that come before us, he asks very relevant, very good questions that for insight,
Chuck
so.
has that kind of information for us too.
We do. And Chuck's a witness, so he's able to tell, he had the floor to tell us whatever he wanted to tell us.
So if Mike's gonna ask any questions, does that be done before the closings? Is he,
Yeah.
would be the next thing?
It would be,
Correct?
it would need to be done, yeah.
Yeah, so we can recess and see if there's any other testimony that anyone wants to provide, any other exhibits. We can move forward
So what,
at our next meeting
what
with that.
are you guys saying as far as testimony?
Well, I'm not quite sure how you want it. If you decide to ask or to proceed with entering an exhibit,
I don't,
yeah,
I disagree,
you may
I don't
need
think
to-
any board member can exhibit.
No.
That's
any-
correct, and I'll refrain from exhibits, but I do have the opportunity to go through the exhibits that have been submitted and ask questions based upon those.
okay, and that's true. I thought you were going down the path of
Along
potentially-
with, we have taken notice to the previous zoning text amendment hearings evidence, which I can associate with the correct witness and ask the question thereof.
That's true. I thought you were going down a different path, so.
I understand my breadth and depth at this point.
Yeah, I mean,
That's the decision.
before we start closing statements, we can, any zoning board member that has questions of anyone on this matter, I mean, I would hope that we all go back and take a look at our documents that we've got all the exhibits in now, and that we come back, if we have any final questions, we have the opportunity to ask them, the zoning board members. Because before we sit down and discuss this, we need to make sure you have all the questions answered in your head that you may have about
Questions of who?
anyone that's testified.
So
Now,
we'll-
if they're not all here,
That's
that could be a problem, but, you know, I guess I've gotta remember that you haven't done this for very
Right.
long, so we always have that option of being able to ask questions. We need to be cognizant of who's not coming back.
Yeah.
Questions that I have are gonna be for the applicant, they're going to be here.
Okay.
I would be taking a chance on not being thorough with my questions on someone that testified and presented evidence if I didn't ask the question when they're here, because there's no requirement that they come back every day.
So they do this before the closing or after the?
We
Before,
would do it before.
because we close the evidence, there's no more evidence after, once you get to closing, there's no more evidence taken.
There is no more evidence, but the questions still remain until we close the public hearing.
Right, you can still,
So at any point in time, if there's rebuttal,
there's not rebuttal.
closing statements, and a question is drawn back to the applicant, we have the opportunity to ask it again.
During the
hearing
closing,
part.
during the closing.
During the
statement.
closing, until the public hearing is closed.
Right. Which means motion. When we close the case, it's with a motion. And then we discuss amongst ourselves, we don't ask questions, and we don't take questions, and we don't take any more evidence.
Right. So
It's amongst
by
ourselves.
closing, you mean, is that after everybody's had their closing statement?
Yes, we close the case after.
After all the closing statements.
Yeah.
Yes.
So, let me ask, I'm new here too, I mean, so like, we're gonna meet again on October fifth, say. There could be more evidence coming in. Where do we stop?
There's no more evidence.
There's no more evidence.
So after tonight, that's it?
Once you get to closing, you cannot submit new information in closing.
Okay. So that's what I'm
I will
trying to
probably
say.
ask one more time if there's anyone else that wants to present evidence. I don't expect anyone to be here. I was gonna give Mike that courtesy, if it's just questions,
Oh,
then the zoning board members at that point in time, be ready with your questions when we begin the meeting. Because if you don't ask then, once they start closing statements, you can potentially interrupt and ask. It's not the best practice, but once closing statements are done and we close the case by saying there's a motion on the floor, then no more evidence, no more questions, so.
that's what I was getting at. So on October fifth, we'll just be redoing this and going through our stuff, right? There'll be no more people coming forward, what I'm saying.
Everybody that's presented evidence is gonna have an opportunity to make a closing statement. They should only touch
It's
on
a
topics that
precondition
they
when people
already
go
testified to
Yeah.
if they're here.
On October fifth.
Right.
Okay.
So you will be listening to people talk. Right?
Yeah.
I guess, cause for your benefit, if you haven't done this many times,
Just
you're
like
gonna
any
listen
other
to
case
people
we
talk.
have, we ask if they have a closing statement, and they say no.
Okay.
Yeah, a lot of times, I asked that gentleman from Gray Mount Co-op, did you have a closing statement? He said no. The testimony speaks for itself in many cases, but in something like this, there'll be closing statements.
So, give me a timeline. You think that all the closing statements will take place on October 5th? Nobody's got long-winded here, are they?
Well, in the past, we set time limits too.
We only had, I mean, I had 8 folks, well, 9 if I include, 9, Julie was 9, and then John being number 10 for folks that testified.
And they can't present any new evidence anyway, so they can just
Basically,
rehash.
rehash, support.
Interpret RB.
Yeah.
Couple months ago.
Does that help? Answer your question? What your question was?
So will we get more done than just closing statements on October 5th? You don't know the answer to that.
Hopefully, we'll get into discussion.
Right.
Okay.
I would assume we'd get into discussion, but there's, right now, at this point in time, I don't see a need to put a time limit on it. I don't think that there's gonna be that much in closing statements unless we're gonna hear a complete rehash of the evidence, which may or may not take your weight assigned to that individual and kibosh it. I don't know, so.
Mr. Redley Schaefer, do you know how long it'll take you for closing?
A minute?
Right?
A minute, maybe?
Oh, I can.
Okay, so are we?
Heard that from
we
Blazer
comfortable?
once, 15 minutes. 2 hours later.
Okay, I might have to object to comparing him to Mike Glazer.
First off, thank you, counsel. Can I just ask? Just a point.
Sorry, I couldn't help myself.
With, I certainly understand the rules of everybody who's offered testimony having a chance to close. If they're not here, are we deeming that as a waiver of that opportunity?
Yes.
Thank you.
And it's represented by an attorney, the attorney makes the closing argument for them, so.
Correct.
Yeah, so that will go down on my number, sure. Okay. Have we hashed everything over enough for tonight? Need a motion? We'll take that action again as a motion.
Yeah, I would close.
Okay.
Recess, we'll recess.
Recess.
Recess, whatever. Go home,
To
go to
October
bed.
5th at 7.
Good.
Thank you.